I would like to thank all the um, very articulate advocates for the Second Amendment and our right to defense of ourselves, who happen to be women. That's all. They just happen to be women, but they've all accomplished so much and bring a new perspective that sometimes that we forget. And I'd like to thank you all very much. Now we're going to go and we're going to head in an entirely different direction. We're going to talk about the Second Amendment doctrine, and I would like to invite Joseph Greenlee, who is the Director of Research at the Firearms Policy Coalition, and Dave Kopel, who is the Research Director at the Independence Institute. And I know I saw Joseph in the back of the room a few seconds ago. He's holding out for more pay. Well, we know what everybody gets paid here, just as much as I do. The late Mr. Greenlee is coming. Now, although these two gentlemen are attorneys, I am going to step away from the podium for a few moments. I'd like them to remember that they're not being paid by the word, and I will be back. Do you all want to use this mic, or do you want to share a mic on the table?
The mics on the table are now hot.
Well, they're hot. If you'd like to do that.
Or stand, whatever you want.
Is it okay if I stand? Is that okay?
It's fine.
Thank you. I was going to use this one. Is that okay? Thanks. Kind of like this? Okay. So I'm going to provide a quick summary of the Federal Circuit Court cases that have been decided over the last year. I'm afraid this won't be the most uplifting speech of the day, but the only positive spin I can put on it is that the 150 judges that Mr. Gottlieb was talking about over the lunch break, this will really make you appreciate those. So the first case is Gold versus Morgan. It's a First Circuit carry case. For a general carry license, the cities of Boston and Brookline require an applicant to demonstrate that they have a greater need for self-defense than that of the general public if they want to get a carry license. The Gold plaintiffs wanted general carry licenses, but they were only granted restricted licenses. For example, one of them could only take their gun to the range and back, couldn't take it out in public for any other reason. The First Circuit determined that the right to bear arms applies beyond the home to some extent, but not as strongly as it applies within the home. And because it applies with so much less force outside of the home, it can be limited to only those who demonstrate a special need for it. The second case is Colt versus Raoul. It's a Seventh Circuit case. Illinois prevents non-residents from applying for concealed carry licenses in Illinois unless, one, they have permits from their home states, and two, their home states have licensing standards that are substantially similar to those of Illinois. And because Illinois determined only 4 states total have substantially similar licensing standards, those being Arkansas, Mississippi, Texas, and Virginia, residents of the other 45 states are categorically prohibited from even applying to exercise their constitutional right within the state. And the Seventh Circuit said that was okay. The third case is Association of New Jersey Rifle and Pistol Clubs, Inc. versus the Attorney General of New Jersey. It's a Third Circuit case. In June 2018, New Jersey reduced its magazine limit from 15 to 10 rounds. Owners of the newly outlawed magazines had until December 10th, 2018 to destroy or surrender the magazines over 10 rounds. The court acknowledged that many millions of magazines are typically possessed by law-abiding citizens for lawful purposes, and that these magazines are essential to the function of firearms that are owned in the millions, but nevertheless determined that the ban was not severe enough to violate the Second Amendment. One silver lining was the dissent from Judge Bibas. He's a recent Trump appointee, and he offered a very compelling argument against the weak test that courts have been using to uphold gun laws over the last 11 years. And he made about as strong as a case as you can. The fourth case is Werman versus Healy. It's a First Circuit case. Werman is a challenge to the Massachusetts ban on so-called assault weapons and large-capacity magazines. There was evidence introduced in the case that over 10 million assault weapons are owned and over 100 million magazines are owned in the United States, and the plaintiffs argued because they're so common, the government should not be able to ban them. This argument's consistent, seemingly, with the Supreme Court's Heller decision, which said that because handguns are so common, you can't ban those either. The First Circuit disagreed and held that despite their popularity, the government's interest in banning these guns outweighed the public's interest in owning them. The petition for cert in this case is due on Monday for anybody who's interested in following that. The fifth case is Wilson versus Cook County. It's another Seventh Circuit case. In November 2006, the Cook County Commissioners of Cook County, Illinois, banned the possession of so-called assault weapons and large-capacity magazines. The Seventh Circuit upheld the ban. They finally got to the Seventh Circuit. I think the challenge was brought over a decade ago. I could be wrong about that, but they got before the Seventh Circuit, and they upheld the ban based on the Seventh Circuit's previous holding in Friedman versus City of Highland Park. The court claimed that no authority or developments that post-date its Friedman decision required it to consider that decision. I think that may have been a mistake. The Supreme Court rejected a very similar test in Caetano versus Massachusetts in 2016 as was applied in the Friedman case in 2015. Both the Friedman test and the test rejected in Caetano asked whether the banned arms existed at the time of the founding and whether they were sufficiently related to militia service. And as the Supreme Court noted in Caetano, neither of these things matter. Rodriguez versus City of San Jose is a Ninth Circuit case. Ms. Rodriguez called 911 and reported her husband when he was suffering a mental health episode. Law enforcement came, and in addition to sending her husband to the hospital, they seized 12 firearms, and they wouldn't give them back. So Ms. Rodriguez re-registered all the firearms in her name only, got clearances to own guns from the California Department of Justice, got the special safe that California requires if you want to own a gun while you live with a prohibited person, and the city still wouldn't return them. Ms. Rodriguez alleged that this violated her Second Amendment rights, among others. In short, the Ninth Circuit declined to address the argument. They said that a state court had previously addressed a similar enough version of the claim, and so that will teach Ms. Rodriguez for trying to do the right thing. The seventh case is United States versus Class. It's a D.C. Circuit case. Federal law prohibits the possession of firearms on grounds of the United States Capitol. Rodney Class parked his car on Maryland Avenue, about 1,000 feet from the Capitol. While Maryland Avenue is a public road, Class parked in a spot that's reserved for employees of the House of Representatives. Class locked his car, went into the Capitol, came back a while later and saw officers peering in through his windows. They asked him, "Do you have any guns in there?" And he said, "Yes, I have 3. So he was convicted for possessing firearms on Capitol grounds. He appealed it. The Supreme Court in Heller identified as presumptively lawful prohibitions on the carrying of firearms in sensitive places such as schools and government buildings. The D.C. Circuit decided that the parking spot that he parked in was it was a sensitive place because it was sufficiently integrated with the Capitol. The eighth case is United States versus Torres. It's a Ninth Circuit case. Torres challenged the prohibition on illegal aliens possessing firearms. Previously, the Fifth and Eighth Circuits have held that illegal aliens are not protected by the right at all. The Seventh Circuit held that the Second Amendment protects illegal aliens, but those with substantial connections to the United States, but even they can be prohibited from, even though they're protected, they can still be prohibited from owning guns because they are difficult to track, not law-abiding, and have an interest in eluding law enforcement. The Tenth Circuit didn't decide either way and said whether they have protection or not. The federal ban withstands scrutiny. The Ninth Circuit followed the Tenth Circuit in saying we're not going to decide whether they're protected because either way they can be prohibited from owning guns. A few months later, the Ninth Circuit reached the same holding when dealing with a non-immigrant visa holder. and that case was United States versus Singh. United States versus Cox is a 10th Circuit case. In 2013, Kansas passed the Second Amendment Protection Act. I'll call it SAPA. SAPA provides that a firearm that is manufactured and owned in Kansas and remains at all times within the state borders is not subject to federal law. Relying on SAPA, Shane Cox began selling homemade suppressors at his Army surplus store in Kansas with a copy of the law right next to the display case. Jeremy Kettler purchased one with both parties under the impression that it was perfectly legal. Mr. Kettler even posted about the whole ordeal on Facebook. I'm not sure if it's related, but soon after that, they were both charged with several crimes, including violations of the National Firearms Act. They challenged the constitutionality of the NFA and argued that SAPA provides them with a valid defense. The 10th Circuit disagreed, held that the NFA is a valid exercise of Congress's taxing power, as well as Congress's authority to enact laws necessary and proper to carry out that power. The 10th Circuit held that short-barreled rifles are not protected arms and that suppressors are not arms at all. And lastly, the 10th Circuit considered whether the defendant's reliance on SAPA was a valid defense. It was not. The court said that expressly stating reliance on a state law expressly, even if it expressly states that their conduct is legal, is not necessarily a defense. This next case has a similar theme. It's the United States versus Viola. It's a Fifth Circuit case. Viola previously pleaded guilty to a nonviolent Louisiana felony for which he received an automatic first offender pardon after he completed a sentence. At that time, he received a letter stating that from the state stating that effective March 14th, 2011, all rights of citizenship and franchise are restored in Louisiana. Viola then reached out to local law enforcement to make sure he can buy a gun, and they said yes. And his dad was a little nervous, so he called law enforcement too and said, "Are you sure that my son can buy a gun?" And they said yes. So Viola bought a gun, and sure enough, he was charged and convicted of being a felon in possession under federal law. This was based in part on a Supreme Court case decided the year before Heller in 2007. Heller was decided in 2008. And that case says that it's federal law, not state law, that determines when an offender's right to possess firearms is restored. And if state law places any residual restriction on the right to possess any arms in any manner whatsoever, then federal law bars all possession of all firearms in all cases. In doing so, the Supreme Court held that, or expressly noted that it was treating the Second Amendment unlike any other rights and differently than the right to vote or right to serve on a jury, where state law governs the restoration of the right. Here, because Viola was still ineligible for a concealed carry permit in Louisiana, if he were to apply to one and he didn't, he was still prohibited under federal law from owning a gun. So despite being told repeatedly by the state that he could own a gun, he's now serving a 3-year sentence in prison. O'Kelly versus Craig is an 11th Circuit case. John Harley Turner, who they call Harley, so I'll do the same, noticed some people hunting raccoons on his property and threatened them if they didn't leave. And at the time, he was wearing a shoulder holster with a handgun, just working on his property. The hunters called the police, and officers soon arrived at Harvey's property. Harvey spoke to the officers from behind a gate that was separating him from his property from the public. The officers were on the public property. He was on his own, and they had kind of an aggressive back and forth. It went on for over half an hour, and eventually said, "I'm tired. I'm going to bed. Can you guys please leave?" Maybe he didn't say please, but can you please leave? I can't help myself. And so anyway, he goes inside, and the officers aren't leaving. And so he comes back out, and it goes back and forth for a while. And anyway, so he goes in one time, and the officers devise this plan and say, next time he comes out, so one of them jumps over the fence and hides on his property behind a bush with a shotgun filled with beanbags filled with shot. And they lured him over to talk to him at the fence, and the officer on the property shot him with the beanbags. 3 of them knocked him down. He reached for his gun. I don't know if he pulled it out or fired, but then the officer shot and killed him. Harvey's family brought an unlawful death action. The district court dismissed it, but the 11th Circuit reversed, allowing the family to proceed with the action, saying that Mr. Harley had a constitutional right to keep and bear arms on his property in defense of his home, and he was doing nothing wrong that gave law enforcement the right to seize them on his property. And the last case is Guedes versus ATF. It's a DC Circuit case. This is a challenge to the Trump administration's rule classifying bump stocks as machine guns under the NFA. It was brought by FPC and individual bump stock owners. They sought an injunction to prevent the rule from taking effect. The DC Circuit denied the injunction, but the remaining plaintiffs petitioned the Supreme Court for cert a couple of weeks ago, so we may be hearing more about it. The rest of the cases for the year were prohibited persons, people convicted of felonies owning guns, and in short, none of those were successful, at the circuit level, at least. Thank you.